Shenanigans at every corner, sarcasm a holy sermon in style. Dark chocolate melted chaos warmer. Fighting this timeline with snark. Every soul welcome but no recorders. Baptized by laughter in the dark. We stand tall, scorning fake orders. In the search of glory rise, with chaos and shenanigans bright. Chocolate and sarcasm our rise. Together we light up the night.
Hey guys, it's Mo, and we are getting into opening statements in Nevada versus Deborah Redden, the very famous defendant who scarily leapt over the judge's bench to try to attack a judge who was going to sentence him to prison for committing crimes while he was on probation or parole. So, this is definitely going to be an interesting case. I do believe that the defense has hinted at a mental health sort of defense. And while we are talking about crafting, which we weren't, but I'm segueing, uh, this is how much I've gotten done on my current project. It is eventually going to look like this. And if you do want to maybe jump into cross stitching, tapestrymarket.com has really good kits. They have stamped kits, which is what this is. Now, I have heard tell that people actually count out and just go with a blank canvas. That is not me. I am too much of a chaos, shenanigans person to try to do math and craft at the same time. And they have subjects other than Sailor Moon. So, you don't have to be, allegiant to Sailor Moon. They do have landscapes and things like that if you do want to try it. This table stand I got from Amazon. If I remember it, I will try to put the link up. I do like this table stand because it allows you to scroll. Although it does make a fun noise, it allows you to scroll with your work as you're moving through colors or trying to get some other things done. So I am really impressed with it, and it was only about $40, which I know is an investment and maybe not more than you want to spend, but I have really enjoyed it. Anywho, let's get into the action. You're like, I didn't come here. I wanted the trial. But I'm trying to be more, showing you guys what I'm working on and what I've gotten accomplished and things like that. I always have goals to improve. But let's get into this. This was from yesterday. They did not start opening statements until 4:30, and we will be speed running this as much as possible. So we might actually get into day 2 and kind of get caught up, is my hope. So let's get into this. I should have everything sound up and ready to go. So this is Mr. Redding.
Okay. Are we ready to proceed? And you wanted me to read this instruction before you gave your opening.
It needs to be read before we introduce the evidence. I don't know what Mr. Arnold's preference is as to whether it's read before opening.
It can be done with your introductory remarks, Your Honor. If you're reading instructions, because it is going to be introduced, like we said, probably off of the first witness. And so we don't want to take the time then to go ahead and, do the Travis instruction.
Okay. Okay, I'm gonna go ahead and, let's go ahead and bring the jury in, and I will read it right after I finish my instructions before they get up to do their opening, okay?
Thank you, Dawn.
I'm hoping that this judge will keep control of her courtroom. I can imagine that this could devolve with sort of a lot of hot button issues and things like that going through criminal justice reform. Should prisoners or should people be given infinity chances? So I do hope that the bailiffs are paying attention and everyone is, doggone it, Nanny Goat. I really must call their manager, but I have to get my Sarah wig on.
I'll press it, Your Honor.
I was about to say the longest doggone jury file-in I've ever seen.
Will counsel please stipulate to the presence of the jury?
Yes, Your Honor.
Defense
Right.
does.
You may be seated.
Guys, at the end of the day, we should.
Okay. Okay, ladies and gentlemen, you are admonished. No juror may declare to a fellow juror any fact relating to this case as of his or her own knowledge. And if any juror discovers during the trial or after the jury has retired that he, she, or any other juror has personal knowledge of any fact in controversy.
So this is actually a stamped pattern. These are washable inks that will come off with hot water and soap. Just don't ever get any of these wet or have, terrible feral children. I have lost a couple kits where, someone will drop water on it and it blurs the pattern. I've heard tell people count these things. I have neither the patience nor the counting skills to do that. I do get all of my kits from Tapestry Mart. Their price point is really good and they're fairly quick shipping. And they have more than Sailor Moon. So, if you like Disney characters or other characters, Lord of the Rings, Star Wars, they even have a Freddie Mercury pattern that I will probably be starting for Sarah Boone, hopefully, which is why I'm trying to kick butt on this, because my general rule as a semi-chaotic person is to not start one project without finishing another because, I've learned the hard way. I am simply not mature enough to have multiple projects going at once.
Controversy in this case, he or she shall disclose such situation to me through
And
Officer
this is
Black
what it will look
in
like
the
at the
absence of
end.
the other jurors. This means that if you learn during the course of this trial, you are acquainted with the facts of this case or the witnesses, and you have not previously told me of this relationship, you must then declare that fact to me. During the course of the trial, the lawyers for both sides are not permitted to converse with members of the jury. These individuals are not being antisocial. They are bound by ethics and the law not to talk to you. To do so might contaminate your verdict. You are admonished additionally, you are not to visit the scene of any of the acts or occurrences made mention of during this trial unless specifically directed to do so by the court. Would that
Okay.
also?
In fear of becoming letting my inner Bronca go, why does she look like her hair looks almost done, and then it looks like she just went, "Nah, let's mess it up just a bit." A travel brush. Look, as much as of a chaotic, neutral, goodish, semi-human being that I am, I carry a little brush in my purse because my hair has been known to, well, frizz out. You're a judge, ma'am. Do that too.
Also means, when I say no investigations or to visit the scene, I mean you don't just not do it physically. You don't do it by using your handheld devices, your iPads, your phones. You don't Google Earth. You don't do any of those kinds of things. Everything you are going to learn about, you're going to learn about within this courtroom. Ladies and
Not
gentlemen, what I
yet.
will now say is intended to serve as an introduction to the trial of this case. It is not a substitute for the detailed instructions on the law, which I will give you at the close of this case and before you retire to consider your verdict. This is a criminal case commenced by the state of Nevada, which I may sometimes refer to as the state or the plaintiff, against the defendant, Mr. Redden. The case is based upon an indictment. At this time, or actually a second amended indictment. The clerk will now read the second amended indictment to the ladies and gentlemen of the jury and state the plea of the defendant to that second amended indictment.
District Court, Clark County, Nevada, the state of Nevada plaintiff versus Deobra Delone Redden, defendant, case number C24380-558-1, Department 22, second amended indictment, state of Nevada, county of Clark, the defendant above named, Deobra Delone Redden, accused by the Clark County Grand Jury of the crime of attempt murder, victim 60 years of age or older, committed at and within the county of Clark, state of Nevada, on or about the 3rd day of January 2024 as follows. Count 1, attempt murder, victim 60 years of age or older, did willfully, unlawfully, feloniously, and with malice aforethought attempt to kill Judge Mary K. Holtis, who is 60 years of age or older, to wit, during rendition.
And this is going to be the crux upon which this case is sort of argued from different lenses. What the defense is going to say is that this was in no way an attempted murder. This is being overcharged. It was, if not a simple assault, an aggravated assault. This was not, him attempting to unalive someone. Now, the problem with that I think he's going to run into is that medical professionals will tell you an elderly person, blows of great force to the head could be considered deadly. In fact, anyone who's seen any sort of reality is going to realize that, traumatic brain injuries are quite deadly. So that is definitely going to be, I think, a stumbling block. I think another point of contention will be the fact that he was making a relatively coherent and well-reasoned thought, at least a self-serving thought, right before he attacked the judge. And I don't know that the fact that he was able to reason and logic his point as to not go to jail, but then he suddenly was struck by a fit of insanity. It doesn't quite gel, but I am interested to see how the defense is going to play that.
Of sentence, and once he knew she was about to sentence him to prison, did leap over defense counsel table into the well of the courtroom, thereafter rushing towards the judicial bench and jumping over it Superman style directly into Judge Mary K. Holtis's judicial space, landing directly on top of her and immediately attacking Judge Mary K. Holtis by grabbing her, pulling her hair, placing his hands around her throat, and or hitting her on the head by manner and means unknown. Dated this 3rd day of September 2024, Stephen B. Wolfson, Clark County District Attorney, by Elizabeth Mercer, Chief Deputy District Attorney, to which the defendant has pled not guilty to.
Please understand that the second amended indictment is simply a charge, and it is not in any sense evidence of the allegations it contains. The defendant has pled not guilty to the second amended indictment. The state, therefore, has the burden of proving each of the essential elements of the indictment beyond a reasonable doubt. As the defendant sits there now, he is not guilty. The purpose of this trial is to determine whether the state will meet that burden. The trial will proceed in the following order. 1, the parties have the opportunity to make opening statements. What is said in opening statement is not evidence. The statements simply serve the purpose of an introduction to the evidence which the party making the statement intends to produce. 2, the state will introduce evidence in support of the indictment. This is called the plaintiff's or the state's case in chief. After the state presents evidence, the defendant may present evidence, but is not obligated to do so. This is the defendant's case in chief. If the defendant presents evidence, the state may present rebuttal evidence. 5, if the state presents rebuttal evidence, the defendant may present surrebuttal evidence. 6, after the evidence, I will instruct you on the applicable law. You must not be concerned with the wisdom of any rule of law stated in these instructions or in the instructions which I will read to you after the evidence, regardless of any opinion you may have as to what the law ought to be. It would be a violation of your oath to base a verdict upon any other view of the law than that given you by me. 7, after the instructions on the law are read to you, each party has the opportunity to present closing argument in support of their case. What is said in closing argument is not evidence, just as what is said in opening statements is not evidence. The arguments are designed to present to you the contentions of the parties as to what the evidence has shown and what inferences may be drawn from the evidence. Your purpose as jurors is to find and determine the facts. Under our system of criminal procedure, you are the sole judge of the facts. You determine the facts from the testimony you hear and the other evidence, including exhibits introduced in court. It is up to you to determine the inferences which you feel may be properly drawn from the evidence. It is especially important you perform your duty of determining the facts diligently and conscientiously, for ordinarily there is no means of correcting an erroneous determination of facts by the jury. The parties may sometimes present objections to some of the testimony or other evidence. It is the duty of a lawyer to object to evidence which he or she believes may not properly be offered, and you should not be prejudiced in any way against the lawyer who makes objections on behalf of the party he or she represents. At times, I may sustain objections or direct you disregard.
Sir, you're kind of on trial for attempted murder. Maybe pay the hell attention. I mean, you're checking your cuticles like you could not be bothered is probably not going to be a good look for the jury.
Certain testimony or exhibits. You must not consider any evidence to which an objection has been sustained or which I have instructed you to disregard. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Remember, statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorneys stipulate or agree as to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuation suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must not be influenced in any degree by any personal feeling of sympathy for or prejudice against the state or defendant. Both sides are entitled to the same fair and impartial consideration. In considering the weight and value of the testimony of any witness, you may take into consideration the appearance, attitude, and behavior of the witness, the interest of the witness in the outcome of the case, if any, the relation of the witness to the defendant or state, the inclination of the witness to speak truthfully or not, and the probability or improbability of the witness's statements, and all of the facts and circumstances and evidence. Thus, you may give the testimony of any witness just such weight and value as you believe the testimony of the witness is entitled to receive. There are two kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw, heard, or did. Circumstantial evidence is testimony or exhibits which are proof of a particular fact from which, if proven, you may infer the existence of a second fact. And I'm going to give you an example of both. You know, it's been pretty hot out there.
Tell
and
me
I understand
rain.
it's going to get hotter probably in the next several days before it starts cooling off. I want to take you up to Mount Charleston in the middle of winter, okay? I'm going to take you up there in the evening, and it has just snowed, and you see this beautiful blanket of undisturbed snow. Now, it's pretty well lit because we've got a full moon up there. So you got the full moon, you got this beautiful blanket of undisturbed snow among the trees, and as you're looking at the scene, you happen to see a bunny hop through the snow. That is direct evidence that the bunny was there. You saw it. You saw the bunny hop through the snow.
Okay, I was wondering where we were. Yes, this is a different judge. This is not the same judge. Obviously, I think that you could be in no way objective if you were the judge attacked. I do question whether this was maybe a power move, which might explain why she has Fox News, giant country music hair. Which, hey, if you can get that kind of volume, God bless you. But I do wonder if it was optically decided, and I know there's really not supposed to be politics involved, to have another woman judge preside over this case to kind of prove a point, or if she was just the luck of the draw. So I'm not sure. I think that dang it. Dolly, why is it that good things can never happen to us, like them agreeing to show that?
Okay, I'm going to take you back. Full moon, dark sky, shining on this beautiful scene, except there's one difference. The snow is not totally undisturbed. There are bunny tracks already in the snow. You didn't see the bunny there, but it's fresh tracks. You can infer that is circumstantial evidence that the bunny was there. Okay? You may consider both direct and circumstantial evidence in deciding this case. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any evidence. No statement, ruling, remark, or comment which I may make during the course of this trial is intended to indicate my opinion as to how you should decide the case or to influence you.
Well, Sal, you missed him cleaning out his fingernails. But yeah, he's been somewhat apathetic looking. He's got a flat affect, but I think his lawyers kind of told him, hey, maybe you look like you give a darn. Allegedly.
You in any way in your determination of the facts. At times, I may even ask questions of witnesses. If I do so, it is for the purpose of bringing out matters which I feel should be brought out and not in any way to indicate my opinion about the facts or to indicate the weight I feel you should give to the testimony of the witness. I may also find it necessary to admonish the lawyers. And if I do, you should not show prejudice or against the lawyer or his or her client because I found it necessary to admonish him or her. Until this case is submitted to you, you must not discuss it with anyone, even with your fellow jurors. After it is submitted to you, you must discuss it only in the jury room with your fellow jurors. It is important that you keep an open mind and not decide any issue in the case until the entire case has been submitted to you under instructions from me. If you cannot hear a witness, please raise your hand as an indication. I might note we do have earmuffs that can amplify the sound if you are having problems hearing. And the only thing I ask that you do is that when we're
Headphones, not earmuffs. Those would do the opposite effect, though depending on the witness, you might want earmuffs instead of headphones. I believe that should be asked. like this witness is incredibly shrill. Could we get those earmuffs we were promised?
we're not in session, whenever I'm talking to the lawyers privately under the white noise, I'm gonna want you to take it off, because literally you're gonna be able to hear what's going on the tables of the lawyers, and you're gonna be able to hear what's going on up here, and you're not supposed to hear that part, okay? Also, I plan to have regular bathroom breaks about every hour and a half or so. I try and peg it so I'm not interrupting witnesses or so forth, but sometimes I may do that. So I'll time it to be right in the middle of the session. But I do appreciate nature calls sometimes, and you just really, really gotta go. Just raise your hand as an indication, and we'll go ahead and take a break right there, okay? I may during the trial take notes of a witness's testimony. You're not to make any inference from that action. I am required to prepare for legal arguments of counsel during this trial, and for that reason, I may take notes. Again, let me remind you that until this case is submitted to you, 1, do not talk to each other or anyone else about it or about anyone who has anything to do with it until the end of the case when you go to the jury room to decide upon your verdict. 2, anyone else means members of your family and your friends. You may tell them you are a juror in a criminal case, but don't tell them anything else about it until after you've been discharged as jurors by me. 3, do not let anyone
Now-
talk to you about
This is going to be hilarious because, as you guys know, I have been selected to attend pre-jury duty on the 11th. Now, I don't know to what all things this non-communication applies, but it's definitely going to apply to possibly another wig purchase. Mr. Mo's going to be like, wait. The judge said that you couldn't discuss anything with me? That is correct. Okay, she said for you to buy wigs. I am afraid I can't discuss this case with you. Let's be real. I am not going to get on jury duty because, well, anyone has to do with the only thing any opposition has to do is see my YouTube channel. And they're like, no, ma'am, you're free to go. Although I do wonder if I will be able to volunteer as tribute for any sovereign citizen case that may come up. Like, hello, my name is Mo, insert last name, and I would like to volunteer as tribute for any Sovsit land boat captains or Moorish citizens that we have. Thank you and amen.
about the case or about anyone who has anything to do with it. If someone should try to talk to you, please report it immediately through Officer Black. 4, do not read any news stories or articles or listen to any radio or television reports about the case or about anyone who has anything to do with it. And again, that means you don't use your handheld devices to check me out or the lawyers out on Facebook or anything like that. Everything you will learn about this case, you're going to learn inside this courtroom. A trial is a search for the truth under the rules of law. Therefore, the court will allow members of the jury to ask written questions of any witness
Ooh,
called
we're
to
going to get
testify in
jury
this case.
questions.
You are not encouraged to ask questions because that is the responsibility of the lawyers.
This is a different
Nevertheless, if
judge.
you believe that an important question has not been asked or that an answer needs clarification, you may submit a question. Keep in mind, a witness scheduled to testify later in the trial may be the best person to answer that question. A question may be asked in the following manner. Please write it down and pass the paper to Officer Black. Make sure your juror number is on that piece of paper. Copies will then immediately be made for counsel and me as the presiding judge. I will then privately confer with the lawyers at a convenient time and then decide if the question is appropriate under Nevada law. Also, when you submit a question, make sure that you are submitting it while we are taking in the evidence. That is when the witnesses are testifying and the exhibits are being admitted. If you start asking the questions during opening statement, we can't help you there. And most certainly during closing argument, we will not be able to open up the evidence to have that question answered. Okay? If the question seeks factual information from the witness and is designed to clarify information about the issues in this trial, I, the presiding judge, or the lawyers may question the witness regarding the points raised in the juror question. No emphasis should be placed on the answer to the question merely because the question came from a juror. If a question submitted by a juror is not asked, no adverse inference can be drawn. The question was simply not allowed under the Nevada Rules of Evidence and must be disregarded. Would either of the parties want the exclusionary rule invoked?
Yes, Your Honor.
Yes, Your Honor.
Okay. If there is anyone present who expects to be called as a witness, please leave the room. Remain available in the hallway. Do not discuss your testimony or the testimony of any other witness with anyone except the parties to this lawsuit and their lawyers. Okay? And
You know, Justin, I haven't seen a lot of deputies, but the camera person is really keeping a tight feed on the judge. My guess is that they have picked special deputies who are a little more on the ball and maybe have the physicality to stop any problems and maybe a different level of situational awareness, considering that they failed so spectacularly the last time. But that would generally involve noticing patterns and forethought, and sometimes the government is good at that and sometimes not, so we'll have to keep an eye on it.
counsel, do you have any, we talked about the admissibility of exhibits before. I'm going to go ahead and the parties have stipulated to the admission of certain exhibits. That's just to save us some time, so they don't have to lay the foundation for it. States exhibits 1 through 33 and 40 through 61 are admitted. Okay? And I have an instruction to give you. Any evidence that the defendant committed offenses other than that for which he is on trial, if believed, may not be considered by you to prove that he is a person of bad character or to prove that he has a disposition to commit crimes. Such evidence was received to provide context to the events upon which the charge is based, and because it was not possible to omit other relevant evidence and at the same time exclude evidence of other crimes. Should we mark that as court's instruction number A?
Yes, Your Honor.
Are you okay with that, Mr. Arnold?
Yes, Your Honor.
Okay. All right, counsel.
Thank you, Your Honor.
Okay, wait, I have a question, Miami Vice. What is up with the open, pop your collar, no necktie thing? I mean, it is jarring only in the sense that both of the other gentlemen at the defense table, the gentleman in the middle is the defendant, look very sharp, have their suits, well tailored, and it looks like they have a good sort of thing. Now, this guy looks like he might have stayed out a little bit late last night and came in like, look, I'm sorry, but it is what it is. Oh, we get a PowerPoint. A PowerPoint.
Do you have the microphone on? I'm about to turn it on right now.
Okay, thank you.
I tried to kill a judge today. Those were the defendant's words mere hours after he violently attacked Judge Mary Kay Holthus in this courthouse on January 3rd of 2024 in courtroom 3F.
In accordance with the laws of the state of Nevada.
YouTube, this is a crime. This is real court TV. And if you let Law and Crime get away with it, you better not ding my live stream. This is, real life. Also, again, Clerk McCute guy, or, young rookie clerk guy needs all of the muffin baskets and possibly whiskey. So the problem is that the state has charged attempted murder. The defense feels like that is an overcharge. They are also going to be using mental health issues. It does seem like there was a medically documented record of Mr. Redding suffering from paranoid schizophrenia. I think that the real problem, and we can go back right here, the real problem they are going to have is that he was making a consistent, if not self-serving statement and argument right before he again decided to attack the judge. Now, there was clear forethought and intent, and he definitely knew what he was doing was wrong because he had to leap. He didn't calmly walk up to the judge and proceed to throttle her. No, he had to leap and get around different bailiffs and things like that. So I will say that I do not know that the insanity plea is going to fly. It could be a mitigating factor, but that is definitely why he accepted a plea deal for all of the other charges, which I think include battery and different things. So that's going to be his problem. But I am not going to replay that unless we can get him trying to argue his case, because I think that's going to be the more damning clip of him. Unintended, Dolly.
Hey, radio somebody? Fucking radio somebody!
We're all here today because of that attack. Judge Mary Kay Holthus is here today because of the bravery and intervention of 6 men. Her law clerk, Michael Lasso, Correctional Officer Joseph Cabralda, Chief Deputy District Attorney Jory Scarborough, Chief Deputy District Attorney Richard Scow, Marshal Shane Brandon, the court marshal in Department 18, where this event occurred, and Marshal Ben Bachhuber, who is the court marshal in the courtroom next door. On the date of this incident, Judge Mary Kay Holthus was 62 years of age. She had been a judge since 2019. She had a mixed caseload, which meant she heard both civil matters and criminal matters. January 3rd of 2024 was a Wednesday, which meant it was a criminal calendar day. In anticipation of her calendar, she went through her calendar before the calendar actually occurred. Mr. Reddin's case was obviously on calendar that day. She reviewed the relevant information pertinent to Mr. Reddin's matter, which was on calendar for a motion to quash bench warrant and rendition of sentence, meaning he was supposed to be sentenced in front of her. The information she reviewed consisted of his pre-sentence investigation report. That report provides her important background information about Mr. Reddin, but also the facts of the underlying offense. She made some preliminary notes. There was nothing particularly unique about Mr. Reddin's case. Then her criminal.
We have a lapel mic.
When Mr. Reddin's case gets called, it's
Okay. So as an auditory learner, and look, I have the same issue when I'm keyed up or I'm settling into a stream sometimes, but there is this tenor in some of, and it's more female voices that I notice it with, but when you're a little jittery, it can almost give like that kind of shaky sound, and you a bit sound like you're going to start crying or you're having an emotional, you're calming yourself down. That's really my only critique thus far. I do wish that she had a stronger, again, you want a pit bull. You want to send a message with this case. if you could likely have found Judge Borowski, that's the kind of, district attorney. Now, again, there might have been, a need to make a statement, or they might have picked this based on, hey, you're just the next district attorney or ADA that's going to get this. I don't know. But if you are going to be trying someone who has so little distrust or so little respect for judges, for the court, then you want to have a pit bull. You want to have someone that comes in and has no nonsense. And that's why the little quaver in her voice is maybe not. That would be basically my only critique. Well, that and her PowerPoint. Could we make an awesome PowerPoint?
Approximately 11:10 in the morning. A little more than halfway through her calendar, which began at 9:30 a.m. When the case gets called, initially, everything is going normal. You'll hear that typically with criminal sentencing, the state gets to argue first. Then a defendant is free to make a statement if he wishes to. In this case, Mr. Ridden did. He argued for probation. He presented the court with information that he believed mitigated against a term of incarceration. After Mr. Redden was done, his defense attorney, Cesar Almasi, also made an argument to the court, seeking probation on his behalf. After Mr. Almasi was done,
Justin Smith, yes and no. And the only way I can see that the state can argue this, and it's more of a potentiality crime, is that the judge is elderly. He did attempt to strangle her and also, hit her with a closed fist, allegedly to the head. Now, in elderly people and even, normal people, all it takes is one ill-placed hit to the head to cause serious, brain bleeding and possibly death. So, it might be an overcharge, but it really does, it really does seem like one of those things where I could see it argued both ways. Now, the defense might say that there were bailiffs. He clearly knew that, he was going to get caught, which would again negate his insanity defense, because you have to be unaware that what you're doing is wrong. And if you made that calculation that you're going to be stopped, so you better get all your, licks in early, then that means you are fully cognizant and aware of your behavior. Well, also you said, I might have tried to unalive a judge,
was done.
those quotes.
But prior to Judge Mary Kay Holthus having the opportunity to impose the sentence that she believed was appropriate, she made a comment, and that comment was interpreted by many people in the courtroom, including Mr. Redden, as indicating that he was not going to receive probation. After that comment was made, and before she imposed the sentence, Mr. Redden jumped over the defense counsel's table, which was approximately 2.5 feet tall and 3 feet deep.
Holy.
He then bolted towards Judge Mary Kay Holthus's judicial bench. As you can see from this picture, the courtroom is set up differently from how this courtroom is set up. There's only one entrance and exit to the judicial bench in that courtroom. He then launched himself 4 feet, more than 4 feet, in the air, and tackled Judge Mary Kay Holthus like she was a football player. He then, once was over the bench and made contact with her, pulled her by the hair as hard as he could, and yanked her to the ground like she was a rag doll. When she testifies, you'll hear that she remembers being struck in the head, but she doesn't remember how it happened. She doesn't remember if it was an intentional act by the defendant, whether her head hit something, an object nearby during this altercation. But she remembers being jolted and frightened. She was trapped. This is the judicial bench in that courtroom. That entrance is the only entrance to or from where she sits when she presides over her calendar. And the altercation that you saw in the first clip happened right there. She had nowhere to go. She was terrified. She knew that she was no match for his physical strength. So she hid. She hid.
Yeah, the more we get into this, I really do not like the quaver in her voice. I want someone up there saying he went up there again in my tone of voice. And I'm criticizing, look, I have never, ever, am ever going to be a lawyer. This face is contempt of court, all right. But you want a ball busting B word in there. Because what you are wanting to do, at least if I were the state, is you want to get that anger flowing. You want to get under his skin. But and he obviously doesn't like women telling him what to do. At least, anything that's against him just getting parole. So if the strategy here is to get him to show that rage again, yeah, you want Carrie Morrissey. You want Dirty Harriet. Now, this might not be their strategy, and this might be a terrible idea. So again, she just does not have a strong, commanding case. This might be, again, nerves. Like I said, I've never had to give an opening statement. She is staying on track, on topic. It is just that quaver in her voice. You want a ball-busting, man-eater up there, in my opinion. Well, you win some, you lose some, half a dozen of one, 6 of the other.
Get as far away from Mr. Redden as she possibly could. She crawled into the corner of that bench and waited there until the entire thing was over. When you watch the full video, you'll see that it took approximately 3 to 4 minutes before Mr. Redden was moved from that location. She was so shaken up, you'll hear, that initially she tried to climb that wall that you see in the picture and exit her courtroom where her court clerk sits. That's not an exit. But she did not want to be near Mr. Redden, and Mr. Redden was still in the entrance when he was eventually apprehended. Michael Lasso was the first person to intervene on her behalf because he was situated closest. Michael Lasso is her law clerk. He's been her law clerk for several months now. He'll tell you about what his job duties are as a law clerk. But more than a law clerk, he is also a close family friend of the Holthuses. He has known Judge Mary Kay Holthus his entire life.
I'm surprised to hear that, and I would just think that might be considered. Well, no, they work together. You're friends with people you worked with. I was thinking, but on after I've criticized her, I am sure this is deeply personal to her as an officer of the court. She probably knows, the judge, all of the staff that was, affected. So as much as I, am over here saying, be a ball busting, mecha thunder cow, I can honestly understand that there are a whole lot of emotions, but this is kind of like being an actor or an actress. You have to put on a persona that will win the case. And you kind of have to think of those things, or at least I would think that lawyers would think of those things. Any hoozle.
He was not supposed to be at work that day. Fortunately, he changed his mind and decided to go
Holy shit. Do we have a Clerks reference? Like, I wasn't even supposed to be here today, dude. I don't know. We've got the dairy milkmaids. We've got the guys who come in for the egg. We're having a Clerks moment, and I'm here for it.
He will tell you that among his many job duties as his law clerk, or as her law clerk, is he sits next to her during the calendars in case something comes up that she needs help with. Thankfully, on this day, he was situated exactly where he needed to be, to her left in that courtroom as she presided over criminal matters. She He was answering emails, performing work, and also paying attention to what was occurring on the calendar. He first realized that something was amiss when
When he saw a foot?
Judge Holthus made a comment and her marshal moved closer to Mr. Redden. You will hear that when her court marshal moves closer to a defendant who appears out of custody for sentencing, that generally means that defendant is about to be remanded into custody. When the marshal moved closer to Mr. Redden and started to unclasp his handcuffs, they jingled. And then he remembers seeing Mr. Redden bolt over defense counsel's table and across the courtroom. Initially, he believed that perhaps Mr. Redden was trying to exit out of one of these rear exits in the courtroom that staff use. But it became apparent to him pretty quickly that his intended target was Judge Mary Kay Holthus. And when you watch the video, you'll see the surprise, the shock in his eyes as he's watching this occur. He remembers Mr. Redden launching himself directly at Judge Holthus and knocking her out of her chair with such force that her head hit the tile wall behind the bench. He immediately knew that he needed to take action because he was frightened for her life and he was frightened for his own life. So he lifts Mr. Redden off of Mary Kay Holthus because he's the closest person to her. He got some assistance along the way. And the first person to come to his aid, and Judge Holthus's aid, was Correctional Officer Joseph Caralda. You will hear that on this date, he was assigned to the Field Services Unit at the Clark County Detention Center. That means that he's one of the correctional officers that's responsible for transporting inmates to and from their court hearings. He's also responsible.
Okay, 2024. We're getting a little, we still have some months to go. If you out crazy yourself, you're gonna be, you're gonna have nothing by the end of next year. You guys, do you know how many? So when I started off this year, I thought I'll do a stream around, Christmas of all the crazy news stories. I'd realized I'd have to do 2 weeks of day-long streams to get all the crazy in. But I'm still planning to do at least a highlight reel of cray-cray.
Responsible for documenting the outcome of those hearings. So he was seated in the witness stand in that courtroom, which is directly next to the judge, but there's no doorway between the witness stand and the judge's bench. So when he saw the defendant go for Judge Mary Kay Holthus and tackle her, he had to climb over that wall to get to the point where he could assist. When you watch the video where the yellow circle is, that's Officer Cabralda climbing over the wall. At this time, Officer Cabralda was the only correctional officer remaining in the courtroom because other correctional officers had just done what they call a download, which means moving defendants who were already done with their cases back to the detention center. You will hear that he struggled mightily trying to get control over Mr. Redden. That Mr. Redden resisted both he and Mr. Lasso and everyone else that came to their aid very hard. At some point, Mr. Redden was able to knock him to the ground. At which point, Mr. Lasso and Mr. Scarborough began to work even harder to get him off of Officer Cabralda, because Officer Cabralda was armed back, which could have presented a whole new set of problems.
All right. So, Mr. Clerk guy, they have these things, they're called electronic boxing targets. I have one. Now, I in no way am a good puncher. Look, I actually watched videos to make sure I was getting the body movements right, but I do know for sure that it's not a windmill thing like this. I think that the entire state of Nevada would be willing to pay for you to go to a Joe Rogan MMA class or training. I'm just saying, sir, we're here for you, you know. Or we would let Chuck Norris teach you. Oh my God, could you imagine that reality show? Real life Walker, Texas Ranger.
Mr. Redden continued to resist, which is why you see Officer Cavalda and Officer Lasso striking him over and over again, because they needed to get him to comply, and he was not getting it. He was still struggling to get away from them, struggling to get back to Judge Holthus. Eventually, they do get him under control. And Officer Cabralda actually uses one of Marshal Shane Brandon's, well, his actual set of handcuffs. He gets one cuff on Mr. Redden, but Mr. Redden's still resisting. So it takes an additional marshal before they can actually get him into both arms into the cuffs. Chief Deputy District Attorney Jory Scarborough was in the courtroom that day because he had another matter that was on calendar, not Mr. Redden's case. He's assigned to a specialty unit at the Clark County DA's office, the gun crimes unit. And you'll hear that as a specialty team deputy, he makes multiple court appearances in a day, oftentimes. So he arrived at Judge Holthus's department at around 10 a.m. and he was still present, waiting for his case to be called when this broke out. Again, he was partially paying attention, partially not, but he got the gist that Mr. Redden's case was on for sentencing. The state wanted prison time. Mr. Redden wanted probation. And then
Mr. Redden wanted to be not
he figured
punished.
out that Judge Holthus was not going to give him probation. He remembers.
Okay, I'm guessing that his attorney did not tell him to keep his mouth on 0.4 font, not underlined. Not underlined, not caps, not, anything else, but told him, like, would you please not make some dumbass faces so you look all the guilty, sir? And his client's like, nah, it'll be fine. Everyone likes to see my, my resting dumb face. Oh, great. My camera is like, no, it'll be fine. But yeah, he has already shown blatant disrespect, disinterest, apathy, and general contempt for the court and the situations he's in my opinion.
Like Mr. Lasso watching Marshal Shane Brandon move closer to the defendant. He looks down to do something else. And when he looks up, he sees that the defendant has already cleared defense counsel's table and is running full speed and hurling himself at Judge Mary Kay Holthus. Like Mr. Lasso and Officer Cabralda, he immediately knew that he needed to assist. So he went around the witness stand, climbed over the same wall that Officer Cabralda climbed over, and tried to wrap his elbow around Mr. Redden's neck to gain compliance. It obviously didn't work initially. He'll tell you that Mr. Redden was elbowing him repeatedly and trying to buck him off so that he could get back to Judge Holthus. But with the assistance of Chief Deputy Richard Scow and the other people who have already—
Those are upsetting.
They were ultimately able to get him to comply. You will hear from both Michael Lasso and Jory Scarborough that once Mr. Redden was under control, their first thought was to check on Judge Holthus. When they checked on her, they saw her still curled up in the fetal position underneath her bench. And she looked terrified. She was frightened, disoriented, shaken. And that really struck Mr. Lasso because he's known Ms. Holthus his whole life. And he's always thought of her as a tough cookie. But in that moment, she was scared. Marshal Shane Brandon, as I mentioned earlier, is assigned to Department 18. He's been assigned to that department for approximately 2 years. As the court marshal, he is responsible for maintaining order and safety in the courtroom during calendars. Because of a previous incident that he had where an out-of-custody defendant tried to flee from the courtroom, it became his practice to stand exactly there. The doors behind him that you see in this photograph are the public entrance and exit doors. So he stands there to prevent defendants from fleeing the courtroom if they don't like the outcome.
Yeah, so I may be different than a lot of people. I think that opening statements, if I'm a juror, I want you to put in all the scaffolding. I want you to tell me things. I want you to try to keep emotions out of it. I think that closing statements is the place where you can add maybe a little more spice. I wish that she would have stuck with the facts, said, now I would have probably opened with the exact measurements of the judge's desk area and maybe the weight stats and size stats of the judge and the defendant. And then I would have played the video after giving the, jurors a little bit of a story. Like, imagine you're a judge and you're there doing your job. You have a space of 3 feet by 4 feet and no protection. Your only protection is this. Your only exit is over there. And you are basically, here alone with your clerk. And then I would have gone into everyone else's testimony. But I don't know that I would have said terrified, other than maybe that is an element that she has to prove that the victim was terrified or scared or suffering fear. I don't know, but I think I would have kept more emotion out of it and stuck to facts, but she's doing a pretty good job.
Like Mr. Lasso and Mr. Scarborough, he realized that Judge Holthus was not going to give Mr. Redden probation. So he made his way directly behind Mr. Redden, at which point he intended to handcuff him to remand him into custody. He unclasped his handcuffs, and immediately Mr. Redden bolted across the defense counsel table. When you watch the video, you'll see that Mr. Redden hops the table, but Court Marshal Shane Brandon walked around this device that was kind of blocking his path to Judge Holthus. It's called an elmo. And in his pursuit of Mr. Redden, just as he was about to grab his legs, as he was lunging over the bench, he tripped or somehow fell. And when he fell, he sustained a huge gash to his forehead that required 25 stitches. In addition to that gash, he severely injured his shoulder. He didn't initially notice that his shoulder was injured until he stood up in front of Judge Holthus's bench and tried to propel himself over the bench using his arm. At that point, he realized there was something severely wrong with his arm. He had to have shoulder surgery and was placed on light duty until just a few weeks ago, when he returned to full duty.
Oh, just in time to sentence this guy.
Incident. Not surprising. But when he stood up and realized what was transpiring, even after he couldn't get over the bench because of his injured arm, he walked around the desk where court staff sits to assist as best he could, given the circumstances. He passed his handcuffs off to Officer Cabraldo and helped try to restrain Mr. Redden. Eventually, court staff in Department 18 alerted the marshal next door to the emergent situation that was occurring in Department 18. He is the court marshal assigned to courtroom 3E, which is directly to the left of Department 3F, which is where Judge Holthus's courtroom is. Court staff walked into the courtroom. They were in session, just like Judge Holthus, and said, "We need you now. It's an emergency. Please come now." So he walked out one of the rear exits to the courtroom like that, and then walked into the rear exit of the courtroom where these events were unfolding. When he walked in, his entrance into the judge's bench area was blocked because her chair, the law clerk's chair, had all kind of piled up right there. He moved them, and when he got to Mr. Redden had one handcuff in the cuffs and one still loose. He was still resisting very hard, and they were struggling to get the cuffs on him.
No one yelled taser,
So
taser, taser.
He took control of the loose arm so that the other individuals could get him in handcuffs. Once the defendant, Mr. Redden, finally calmed down to the point where they felt comfortable relocating him, he was taken to the holding cell just to the side of where the court staff sits. And once he was in the holding cell, Marshal Bachhuber and the other marshals that were down there at this point did what they needed to do to document what had occurred in the courtroom.
Okay. Jedi Jess, I have a question. Why is paralegal Miami Vice without a tie? It's more jarring because even the defendant, even though he could not be bothered to correct his face during this testimony or this opening statement, you know, at least he has a nice suit on. But Ferris Bueller over here, nothing. I don't get that look. I really don't.
I think it's the blue jeans, Your Honor. I think it's somebody on blue jeans. I think it's someone on blue jeans.
Oh, it's somebody on blue jeans. Can you review them?
Oh, so this might be where we were watching Debbie Does Dallas, or the state of Dallas versus Debbie, but not in a good way. Oh my gosh. I am glad I'm not a lawyer for this one because I would be snickering. Yes. I would be snickering my ever-living boobs off. So to whatever mad lad did this, terrible, funny, but terrible. And you know who you are, and ashamed, you should be ashamed of yourself.
Oh, God, what? What? Somebody put some inappropriate, video on there. It was inappropriate. Okay, we may not be doing blue jeans or Zoom during the hearing, if that's gonna happen. Yeah. Okay, I'm sorry, counsel,
It's okay.
and I'm sorry. This has never happened. At least not while I've been on the bench.
It was the first time for everything.
The clerk's like, wait, I remember that one. She gets stuck in a wash machine. It's a heartwarming story of sibling togetherness.
Anyways, going back to where I was, Mr. Redden sat in the holding cell outside of the courtroom for approximately an hour or so before Marshal Bachhuber, Marshal Rollinson, and their lieutenant escorted him to the Clark County Detention Center. You'll hear that it's the court marshal's responsibility to book an out-of-custody inmate who was remanded into custody, which is why they had to do it. So they walked him over to the Clark County Detention Center where he began the booking process. You will hear from Correctional Officer Darren Needham and Correctional Officer Elmis Cabrera that during the booking process, an inmate sees both psych and classification. And that's done for the purposes of determining where to house these individuals. When Mr. Redden was seen by sight on January 3rd of 2024, he reported homicidal ideations. Specifically, the report indicates, in regards to homicidal ideation, patient stated, "Only the judge. She sentenced me to prison." He denied having a plan to harm her. He also denied thoughts or intent to harm officers or other patients, or anyone other than.
Okay, the defense attorney is like, you had one job, the right to remain silent. But you said, and I quote, homicidal ideations? No, only that judge I just tried to unalive. You know,
The judge who sent him to prison. Ultimately,
that's when your
because
defense
of
attorney just
his
starts
expression of
drinking,
homicidal
reading your
ideations,
file.
They determined it would be best to house him in Unit 2C. You will hear that Unit 2C is the unit where they send people with homicidal ideations, among other things. But with regards to his classification in 2C, it was because of his statements. So Officers Darren Meekum and Thomas Cabrera went to transfer release, where the defendant had been waiting for classification. They were tasked with the responsibility of getting him dressed out into his Clark County Detention Center uniform, as well as performing what they refer to as a strip search. You'll see the video of them in the area, but there's no audio. Officer Darren Meacham is the taller individual standing at the front. Officer Cabrera is the individual.
So he and his attorney have a tie on. It looks like the paralegal is having a Miami Vice fashion revival and just like, nah, no tie and no top button. Anyone want to see my chest hair?
Off to his left. And when they walked into the cell, it was a single person cell. He was by himself. They observed him casually laying on the bench with his hands behind his head. They gave him commands, told him what they were there for, and he spontaneously stated to them, "Sorry I'm moving so slow. I'm kind of sore today. I tried to kill a judge."
Hello, Shelba B.
Those statements that Mr. Redden made and that violent attack against 62-year-old Judge Mary Kay Holthus are the reason that we're all here today. And when the state is done presenting its evidence, we are going to ask that you return a verdict of guilty as to the only charge in this case.
All in all, pretty. I just wish she would have been stronger
Thank you.
in her vocal delivery. And just say no to shoulder pads, women, especially us hippie women with bigger shoulders. No.
Not right now. I want to make sure his presentation's unobstructed. Okay.
We're good.
May it please the court.
Oh, I'm sorry. Sheba.
Ladies and gentlemen,
I'm very
of the
sorry.
jury, thank you for your time and attention. 3.7 seconds. 3.7 seconds. That was when the officer claps, unclaps the handcuffs. My client heard it, turned and looked at him, and made a move for the bench. This all occurred in 3.7 seconds. .7 seconds, that was not enough time for Mr. Redden to formulate the intent to kill Judge Holtis. Remember what this case is about.
Hey, lawyer guy, it can be made right in that moment. And when you wrap your, murder mittens around someone's neck in a, friendly neck hug, yeah, that's considered murderous. So intent, and take this from a layperson, I would ask a lawyer too, since I am not a lawyer, but intent can be made a split second before. It can be made at any time. A lot of us, I think, especially me, when I hadn't, started watching trials, I figured intent was when you had like, L murder notebook and you had like the whole list and your timeline and, hide evidence. But intent can be made within the second. The minute he decided to put his, murder mittens on, the judge's neck for a little hug, that could be considered intent to unalive. At least I'm pretty sure in theory, because you have, you're cutting off someone's airway. People need air to breathe. I'll have to look up the specific statute and see. Let me see if I can do that while we're looking at
There's
that.
one count of attempted murder. And for there to be an attempted murder, there has to be intent to kill. As everything else in life, the story didn't begin on January 13th. This story actually occurred on April 13th, 2023. This is when Mr. Redden was first arrested for what brought him in front of Judge Holtis. And basically, Mr. Redden was arrested for swinging a metal baseball.
Okay, let me share this tab instead. So for Nevada attempted murder, oh, okay, there it went. I was like, where did my other page go? So you commit the crime of attempted murder in Nevada if you try unsuccessfully to murder another human being. The three main elements of this offense are: you intend to unalive the victim, you took a direct step towards carrying out the unaliving, and the victim did not die. It looks like it's a Category B felony, carries between 2 and 20 years, though if you used poison, the judge can impose a life sentence. Now, exemptions from this are, self-defense, didn't have an intent to kill, or made no attempt to kill. So I believe that the intent happens, within that second. I think as soon as he moved his hands, daggone it, I want this one. I pushed the wrong button. Of course I did. Yes. So in seconds. So his sort of 3.7 seconds, I think, holds no water. But regardless of what I think, and in order for our judicial system to work, as flawed as it is, Mr. Redding deserves a zealous defense of his constitutional rights, and the state needs to be its burden. So I don't know how they're going to, I'm pretty sure statements after the fact where he said, I tried to do that, judge, I'm pretty sure can be used as evidence, but I think that it's going to be a swing and a miss.
Bat at his brother-in-law. What was he charged with? He was charged with assault with a deadly weapon. He was also apprehended by the police, and he was taken into custody. When you're taken into custody, you're supposed to, within 48 hours, stand before a magistrate so they could decide the question of bail or not.
Also, lawyer, maybe not the Kubrick look as you're, trying to defend man who may be slightly menacing and terrifying, considering he lacks control. I don't like his his posture is defensive. Um, I don't he also doesn't have a very strong voice, and I am not liking the general look under the Kubrick, stare at the jury.
Mr. Redden, on April 13th, told the officers that had him in custody that he refused to be transported. So he was just going to stay in custody without these charges being read to him. The following week, they waited some time, continued the matter. On April 20th, 2023, Mr. Redden, he failed to leave his jail cell again. And he says that he wasn't coming to the hearing. They had to continue the hearing. Again, on April 25th, Mr. Redden refused to be transported to the heading. Finally, the Justice Court judge.
So all he is telling me with this is that he refuses to live by any rules other than whatever the hell he feels like, and he has no respect for the justice system, and will continue this sort of pattern of behavior throughout his entire life. I mean, I'm sorry, but all you are putting out there for me as a juror is that he lives by his own rules and he doesn't care. Part of a factor of, incarcerating someone is keeping the rest of society safe. I don't know that these are the points you're wanting to make.
Judge Jacinto, he did an order that says, by any means necessary, he needs to be present in this courtroom. So on April 26th, the officers got Mr. Redden and he was present. The judge then, he's handed the charges. The judge asked him if he understood the charges. Mr. Redden didn't even respond to the judge's questions, even though he had a copy of the information, which was assault with a deadly weapon, on his person.
Good
And not
point,
only
Nanny Goat.
did he not answer the judge's questions, he became disruptive in the court proceedings. At this point, again, we have almost a week plus that.
Everyone else is watching this, right? I have a strange flashback to, I bet you're wondering how this constitutes a defense. Y'all, this is what I have to work. This is the equivalent to Chandler Halderson is a peaceful boy, and he lived peacefully with his parents until he didn't. And it's not like we have recordings of him actually, offing his parents. So really, I mean, this was all an oopsie doopsie.
We see this individual not coming to court. Once he gets to court, he's being disruptive and he's not participating in the court proceedings. At this point, his attorney, which was a public defender, then petitions the court to send him to what's called competency court. Competency court is a whole nother courtroom here in our building. And competency court is for people that do not understand the legal proceedings, are unable to assist their attorneys in their defense, or number three, appear to have some kind of mental condition that prohibits them from acting properly in court. All those things were exhibited by my client, Mr. Redden. He was sent there to be evaluated and see if he can be restored to competency. Restored to competency is basically.
When one is talking about competency, perhaps say it correctly to reveal competency in yourself. I'm sorry, I'm in such a petty mood. I feel bad about that one. But we have these absolute Manson lamps staring at me. I'm sorry. I don't know if this judge or if this attorney told his client, maybe don't look like you have Manson lamps. Here, I'm going to bring you in a coloring book or a Sudoku, and I would like you to look down at the desk and only look up when I pat you on the leg, okay? And practice that face we made where you don't look like a absolute crazy person. I mean, it will help your case, but you come off more menacing than crazy. So, you know.
We can't try you. We cannot prosecute you under the law since you're not understanding what's going on. You're not displaying courtroom behavior, you're not helping your attorney out. We can't sit here and prosecute you. Right. So basically, he's found on May 23rd, he's sent to Lake Crossing. Lake Crossing is a mental institution here in town. And what they do at Lake Crossing is make sure that you're evaluated to test your competency. Sometimes, people are sent there and they have lingering symptoms like they're just making up, acting crazy. Other times, they sit there and evaluate someone and their mental instability is so severe, they just have to stay at Lakes Crossing for an indefinite amount of time because, again, the state can't prosecute you under that incompetency. So in regards to Mr. Redden, he was evaluated and it was determined by Dr. John Paglini, who will be here and he'll testify in regards to this case and in regards to his finding of incompetency. And there are other psychiatrists because there at least has to be two that make that determination. And what they determined was he was incompetent to stand trial. And so he was given a course of medication because his evaluation indicated that during this course of medication that would calm him down, bring him back to earth, bring him to a person that we can work with, that he can go to court, he can understand the proceedings and not be disruptive in court.
Yes, he is going with.
So Mr.
Again, I find major flaws with this because they are going to use pre-existing paranoid schizophrenia. Now, I don't know if any of you have tried to talk to someone in an active psychotic state with paranoid schizophrenia, but people are not able to have, coherent thoughts, arguments, keep control of themselves. I mean, again, he was singing the praises of me and how I'm going to be the goodest boy from now on, right before he switched to attacking the judge. Now, had he said, you are part of the cabal with the Illuminati, I have never had a chance to have a fair trial, I know you guys are recording me. I mean, the more telltale symptoms of paranoid schizophrenia, I think that could work. Now, if the psychiatrist has diagnosed him with, intermittent explosive disorder or, reactive attachment disorder, things that are known to cause split-second intense rage without much forethought, I think that could be a possibility. But again, he was restored back to competency so much and to the point that he was let out on his own recognizance until, sentencing. So while he may suffer from mental health things, in the moment, he knew what he was doing. Point blank, end of story. Now, we can quibble about attempted murder or not, but I don't think that this mental health thing is going to fly.
Mr. Redden, when you go back to that one, I just want to make the last point that he was at Lakes Crossing for 5 months. He was eventually found by the doctors on October 20th, 2023, to be competent to go ahead and proceed with trial. So exactly 5 months later.
The family has been somewhat wishy-washy. I have not found any other interviews other than the ones videoed with the sister and I believe the foster mother. So if he had a history of this, it's not uncommon for people with paranoid schizophrenia and several other mental health conditions to not be great at taking their medication consistently. So again, there hasn't been a whole lot revealed. And my guess is that since he is currently incarcerated, because the judge did in fact sentence him for that particular trial where he leaped over the bench, so he's currently in prison right now. You know, he is probably being monitored very closely for his medication.
Go ahead now, sir. After he returned back to justice court, he was confronted in discussions with his attorney that and they go ahead and enter into a guilty plea with the state of Nevada. And now he right now he's able to discuss his case with his attorney. There's either court anything like that. And so much so, the judge released him on November 1st, 2023. He was released from custody. Okay? He returns to back to court, and now this is district court. This is in front of Judge Holtis. And on December 6th, he has no extreme courtroom behavior and goes ahead and the guilty plea agreement's read to him. He answers a myriad of questions and he pleads guilty to an attempt assault with a deadly weapon. The sentencing was scheduled for January 3rd, 2024. Next slide. What you're going to see through medical records, through the testimony of Dr. Paglini, Mr. Redden did not receive his medication that he had while he was here in Clark County Detention Center. What happened was he gets released and he's given a prescription. That prescription is supposed to be filled at the Mojave Health Center. He calls and you'll hear testimony from Karen Springer. Karen Springer is his foster mother that he stayed with during this time. He made several attempts at appointments, called and attempted to get him in so he could take his medication. However, you'll see through the testimony, he does not get medication. And he doesn't get it for 2 months. So from November 1st to 2020, in November 1st,
Okay.
2023 to January.
No, I'm sorry. You can go to, there are crisis lines. You can go to the emergency room. I'm sorry, but there is no excuse. I understand, but there are people to call. Had you called every day, had you made yourself a nuisance and, or gone to the emergency room and say that you're a paranoid schizophrenic and you can't get your medicine, talk to a caseworker, talk to a social worker, talk to your probation officer. I somehow doubt that there was more than a cursory attempt made to get his medication.
January 3rd, 2024, a period of 60 days, he does not have his medication that put him in that state where we saw the appropriate behavior. What you're seeing today, basically, he's under that medication that he had when he was in CCDC. And that's why he's displaying, good decorum, appropriate courtroom behavior. He's not going to wild out, and trust me, I'll tackle him if he tries to, do anything like that.
Defense attorney, I get that you're trying to lighten the moment, but again, your client has made absolutely clear with his micro expressions, with his, cleaning his fingernails, that he cannot be bothered by this case. So, read the room.
But bottom line, that's not going to happen because he's medicated, he's calm, he understands what the proceedings are and what's going on right now. During this 60 days, Mr. Redden slid back into his unstable mental state. The same mental state that he had when he was first arrested for assault with a deadly weapon and charged and eventually pled to attempted assault with a deadly weapon. Next. Then we have this unfortunate incident that happened on January 3rd, 2024. One thing I
Oh,
noticed.
hell to the no. So wait, it's the court's job to make sure that, a grown A man took his medication today. So Mr. Redding can't be accounted for to control his behavior. He can't be accounted for to not take a baseball bat to, family members. And he also now needs an entire nanny state to make sure he takes his medication. This is optically such a terrible look. Again, this might have worked. This might have worked had, this been part of the lockdown. There were supply chain issues, but he absolutely displayed self-control until he was told he was not going to be getting out of jail free with like a public service, warning. So this is just a gross tact. Again, shifting the blame onto society, the court, CVS, Walgreens. It's just ridiculous, and it shows the mindset that created this conflict.
I looked at this videotape several times from the very beginning to the very end. I know that all the parties involved. A simple question wasn't asked. And I'll explain later as to why it wasn't asked. But no one asked Mr. Redding, did you take your medication today? His attorney didn't ask, the prosecution didn't ask, nor Judge Holtis asked. I'm not saying this is anybody's fault. It simply wasn't done. So he comes into court and nobody knows what his real mental state is during that time. Nobody knows that for 60 days, he's been having paranoid thoughts. Nobody knows that he's been staying at home, not going out into the public, and different other things that were discovered
Okay,
by
so
Dr. Peggy.
so riddle me this, Batman. When he said he got, a job and he was out doing good and he was turning his life around, you're telling me he was in the midst of a psychotic break. He was able to fool everyone in his family and his lawyer, who had seen him behave irrationally before, so had a baseline of that, as you say, wilding out behavior. So he gave no warnings to someone who is intimately aware of what he looks like when he is in a psychotic break. But it's society, it's the court's fault for not asking him if he took his little, adult behave me pill.
That
no.
we'll discuss. Mr. Redding did not intend to kill Judge Holtis. The evidence will show that Judge Holtis, she hurt her head when she struck the wall that was directly behind her, similar to this wall. She also was hurt when she fell on the floor. You'll see pictures. She wasn't significantly bruised. She was bruised, but it wasn't significant bruises. And those were basically on the areas where she fell. She had no cut. She had no strangulation marks on her throat. There will be no evidence that anybody ever that saw Mr. Redding touch her throat. We'll have specific evidence of where his hands were placed right before he was pulled off of Judge Holtis. But again, his actions do not indicate that he was intending to kill Judge Holtis. And again, you always have to go back to intent.
Okay, I'm sorry. Reckless attempted homicide. She would not have fallen. She would not have struck her head on the granite back tiles had your client not abhorred, Newton's second law: for every action, there's an equal and opposite reaction. Or no, that's third. Anywho, she wouldn't have flown back had there not been a significant giant defendant flying toward her. But okay, sir, you had to give it the college try. have you considered writing for Disney Star Wars? Because you at least kind of understand how to make a cogent story.
That is going to be the big question that you guys are gonna have to deal with at closing. Did he have the intent to go ahead and kill? And we are gonna submit that the evidence does not show there is any intent to kill Judge Holtis. Thank you.
Okay. Council approach.
My first question as a juror, can we convict him now? When do we start voting? I've seen all I need to see. Have you guys seen the video? Oh, you guys saw the video? No, we're ready. I mean, what absolute claptrap. Like, well, it was really everyone else's fault. They didn't check his medicines. And what was this poor man to do except his punishment that he pled guilty to? There's a reason the paralegal didn't wear a tie. He's like, oh my gosh, I don't know if I can tell these many shaded truths without feeling all choked up and verklempt. They might be doing scheduling. They did not seat a jury until later in the afternoon. So this took place around
Okay,
4:30.
Ladies and gentlemen, the attorneys were, let's say, a lot more efficient than we anticipated. So we're going to go ahead and finish for the day. I need you back here at 1 o'clock. And remember, you're all like brides. We cannot get started until every one of you are here. So during this period of time, you are all admonished not to talk, converse among yourselves or with anyone else on any subject related to the trial. You're not to read, watch, or listen to any report of or commentary on the trial by any medium of information, including without limitation newspapers, television, the internet, and radio, or form or express any opinion on any subject related to the trial until the case is finally submitted to you. And again, no outside experiments, no visiting the scenes of any of the events that you've heard talked about. Don't use your iPads to find out information about this case. Don't read the newspapers. Everything you will learn about in this courtroom. Have a good evening, and we will see you tomorrow at 1 o'clock.
I'm collecting the notebooks. We'll just do them.
Okay, so it looks like they are doing this on court half days. So today's court date doesn't start until 3:45. So what I will be doing is ending the stream, and then we'll just be a day behind. But as efficiently as they're working, I don't expect this to be a long case. It seemed like there were only maybe at most 10 or 11 witnesses for the state, and then 2 or 3, possibly 4 for the defense. So I will see you guys tomorrow. We will be doing day 2 as they get to it. Honestly, the defense, they have to put something up there, but I don't know that I agree with anything that they're saying. I try to keep an open mind, but I am so tired of this mental health, excuse, and everyone failed me, but no taking personal ownership of anything. So I do think that it's going to be interesting to see how the state presents that he did have intent for unaliving and how the defense is going to refute that. Thank you so much for joining me, and let's see who's doing a court stream right now to see who I can send you to. And those are going to be, looks like we have Recovery Addict and Recovery Addict. So we will go with Recovery Addict, and it looks like he is also covering the bench jumper trial, but he has started his pregame sort of stuff, and he always has fun, cool things and all of the technical stuff that I wish I was doing. I know, I have a puffy floor pillow coming in. Uh, so I'm excited for that to be coming in because when I sit down, I've gotten this footstool thinking that it would work, and it's just not going to work out. So I will be so excited to get my puff tomorrow to put my leg on, and we will sit here and do fun stuff. And I have my tripod set up. So I do have a comfier seat on not so fun pain days that I should be able to just turn everything around on my desk and continue to do live streaming from my comfy chair. So that will be a good thing to have for fall and rainy storms coming in. So thank you guys so much for, giving me a chance, for coming to this channel and watching me craft and do court stuff. So I will see you guys tomorrow. Don't forget, we have Nightly Newsy News tonight at 7. Keep an eye out. We will have all of the crazy, crazy stories, I'm sure, because 2024 is on a roll. And, I will see you guys tomorrow as well because it is Friday. Yay! Oh my gosh. This week has seemed oddly, paradoxically, extremely short and extremely long. I can't make sense of it either. I will see you guys in a little bit. I'm going to go continue to tackle laundry because now don't get peanut butter and jealous because of my glamorous life. But I'm also going to start some, ranch bacon chicken in the crock pot. So there you go. Bye, guys.